Welcome to the Well Off Podcast, where the goal is to motivate, inspire, and share success principles. I'm your host, George Masri. Thank you for tuning in. I interviewed Hussein Kudrati, who's a well-traveled lawyer and entrepreneur. He grew up in Kenya and eventually relocated to Canada. He's currently practicing as a real estate lawyer, and he's based out of Burlington, Ontario. He specializes in working with real estate investors. He's a passionate golfer and fisherman. And on this episode, we talked about using bear trusts, how that could benefit you, a 3-tier corporate structure for real estate purposes, estate planning and how you can save a significant amount on taxes, why title insurance is important. So there's a lot of good things in here for real estate investors. I know you guys are going to enjoy it. Make sure to share this with a friend or family member. That would be greatly appreciated. I think we can spread a good message here. We can teach people how to become well off through real estate. And also, if you are a new investor and you feel like you're not sure if now is a good time to purchase real estate or if you should hold off or whatnot, I encourage you to reach out to me. I'm happy to discuss how we can help you get into real estate investing. I think now is actually a wonderful time because prices have come down so much. So more than happy to have a call with you. Go on the website, welloff.ca, book a call, and I look forward to connecting with you soon. All right, I'm here with Hussein Kudrati. Thank you for joining me today.
Thanks, George. I appreciate the invite.
All right, so let's talk a little bit about your childhood, because that's how I like to start off. Tell me about your journey, where you grew up, and just whatever you feel like sharing about your childhood.
Absolutely. So I was born and raised in Mombasa, Kenya. For those who don't know, it's on the east side of Africa. My family originally is from India, moved there about 5 generations ago. So my parents also were born and raised in Kenya. When I reached high school age, I went to boarding school in the United Kingdom, which was family tradition to go to boarding school there. During that period, Kenya went through instability as the president, who'd been the president for about a quarter of a century, decided to retire, and there was competition for who would succeed him. And my parents wanted to immigrate, and they decided that Canada was the appropriate choice for where they would move. And they said that you're coming with us because we all want to have the same citizenship. I went along because didn't have much of a choice. Did my undergrad at Queen's in Kingston, which was an amazing experience. And then I wanted to go back to England to do my master's degree. My friends were there. I had family there. It's what I knew and what I identified with in Canada still seemed at that point quite foreign. I went back to my master's degree, and that's when I decided that I wanted to go to law school and become a lawyer. And so I thought, where do I want to go to law school? I always viewed education and just through the opportunities my parents graciously had provided me as a chance to see the world. So when I went down that path, I decided that California would be where I wanted to end up. So I applied to California law schools, got in, finished law school in California, prepared to set my whole life up there. And then when I was visiting my parents back in Canada, met my wife, and she said, I'm not moving to the United States. You're coming back here if this is going to happen. And I made the decision to come back here, had paid my dues, lived in Fort McMurray, dealt with a Fort McMurray winter along the way, and, articled in Bay Street and worked at a boutique firm in Burlington. And now for the last few years, I've run my own law firm in Burlington as well.
Very cool. Very cool. So your wife agreed to come to, I guess, Burlington to stay there?
Yeah, as long as we stayed in Canada, it was fine. She came from Pakistan, and again, she viewed Canada as a country that gave her family stability. Because Pakistan again had some instability, and her family had gone through some experiences there that were unpleasant, and so she viewed it that, it's her responsibility now that she's an adult to contribute back to Canadian society.
Right. Very cool. Yeah. So you're a lawyer, obviously, and I know you work with a lot of real estate investors. You're a real estate focused lawyer. Tell us a bit about, we had a couple things here that we want to talk about, but I think the first thing you mentioned was bear trusts. So
absolutely.
For the people that are listening, can you kind of just give a brief explanation as to what a bear trust is and how it might be used? So
a bear trust is a vehicle where if you want to hold a property in a corporation, or sometimes if you want to enter into a joint venture agreement, one party will go on title and will hold the property in trust for another. It could be that they could just be a money partner who is on title, and then there is the silent partner who's not on title and just giving some capital but not actually going to be registered, and it's just captured in the agreement. Or it could just be you yourself but you can't get financing, for example, in your corporation. So it just makes more sense that, okay, what I'm going to do is I'm going to put the title in my personal name so I can get the financing, but I want it to be beneficially owned by the corporation. So that is typically how bear trusts are utilized. Now, why I like to talk about this, especially now, is because I know there are a lot of real estate investors who avail themselves of this structure or the use of bear trust, particularly with JVs, where a lot of people who didn't have capital to buy properties on their own, they partnered up with others, and now we're in a position where they could have some issues. And the reason why, and fortunately got delayed by a year, because there hasn't been a lot of public commentary on it where people are aware of the implications. But the CRA has, well, the government of Canada has said that from December 31st, 2023 now, bear trusts have to be reported on as part of a schedule to your tax return. So if you hold property in trust for someone else, you have to declare that property. So now if you wanted your own involvement in a particular project to be kept silent, it's no longer going to be kept silent because the government's going to know about it as part of this new regulation. And a lot of people who have JVs, and sometimes the percentages are based on, I'm going to give you a percentage, but I get to stay off title and keep my borrowing power and my powder dry. But now these schedules are being reported. It changes the outcome, and it changes potentially financing for existing properties you have. So if you've got refinances coming through after April 30th of next year, you should be talking to your mortgage broker or your lawyer and your accountant to make sure that you're not going to put yourself in a difficult situation where you might have to liquidate properties at a loss, depending on where you're at in your during the stage of your real estate investing on that property, or make sure that your partner who's on title is reporting the trust interest as well, because the penalties, now obviously there's an uncertainty because it's not in place as to how it'll be enforced, but the penalties on paper can be rather draconian. So again, you don't want to end up suffering losses that can be avoided with just understanding where we're at.
Sure. Now, I've never actually been involved in a bear trust in any way, so I don't fully understand it. But just to clarify, why would somebody create a bear trust? Is it for the shelter or kind of the protection that a corporation provides from a liability perspective, or are there other reasons?
A bear trust is simply that you might want to keep your financing power. So I might say that, hey, George and I, let's get, we want to buy like 4 properties together. I'll say that I'll go on title on 2, and you have 50%, but I will be on title for those 2. But now I've exhausted my borrowing power. So you will go on title for the other 2. So that's where bear trusts are used, is basically so that the banks would not see that actually you've already got involvement in this, so you already have exposure, so therefore your borrowing power is lower. So that keeps your borrowing power higher. Other times it could just be that, for example, someone knows that they might be separating from their spouse and they just want to obfuscate their involvement in a particular property. It could be done for those reasons. There are a number of reasons that bear trusts are used. A lot of it is just through the JV structure where it just doesn't make sense, or for financing reasons or availability or all sorts of things that they structure that way. So in
the first example you said, it kind of sounds like it's replacing the JV agreement, or is it working with the JV agreement?
It works with the JV agreement.
So it's just kind of like
the JV is a form of bear trust. Like a lot of JV agreements actually have a bear. So a lot of people, like I've had a conversation with a number of real estate investors over the last few months where they're like, oh, well, I don't know about bear trust. I'm not involved with bear trust. But then when you ask them, are you in a JV? And then
JV means joint venture, in case somebody's listening and doesn't understand. Yeah. Sorry, go ahead.
And then you tell them, well, are you entitled to the property? It's like, no, I'm just a JV partner. Well, I'm like, then your partner owns the property in trust for you.
Yeah.
Right? There's a 50% or whatever the percentage beneficial ownership to you.
Yeah.
So that's the thing. Like, it doesn't have to officially be called a bear trust. You have to also see that, because with a lot of things, if it walks like a duck, talks like a duck, it is a duck. And that's the way CRA will judge it when they're saying that you fulfill your reporting requirement.
Got it. So you're saying that as of December 31st, 2023,
correct,
if you have a joint venture agreement, which technically is a bear trust, you're going to have to report that to the
Not all of them are, but a lot of joint ventures agreements are. So just to confirm, if you have a joint venture agreement where one of you is not on actual registered title to the property, you have a bear trust.
Okay. Right. Okay.
And then the person who is on title has to report that they hold your percentage in trust for you when they file their next personal tax income return in 2024.
And how does that impact the person that's not on title?
because the person who's not on title is now going to be shown that they have a beneficial. So they're going to show there's a beneficial interest. Now, if they're not declaring that beneficial interest, then they're actually filing an incorrect return.
Right, right. But if you are claiming it, which you should be, right? Regardless, you should be claiming that because there's rental income, there's all these things, right?
As long as they're doing it correctly. But a lot of people prefer to stay silent, especially on development projects and things like that where there is no income, because they don't want the banks or the lenders to see it for other projects they may want to do.
Sure. Got it. Okay, cool. Good to know. I've also had a situation in the past where I held a property in a holdco. And then when it came to refinance the property, the mortgage broker said, well, why don't you transfer this property into your personal name and have a bare trust? I didn't quite understand. Like, that didn't make sense to me because I'd have to pay land transfer tax to transfer the property and all that, from my understanding, right? And
so what you can do with a bare trust is often, a lot of times it goes the other way, where you hold title personally and then you hold it in trust for the corporation. And then eventually, when you can get financing in the corporation, then you can do what is known as a nil transfer, which means you don't have to pay a land transfer tax to move the property over.
Oh, you could do that.
So as long as you have the proper trust agreement, because essentially what the bare trust is saying that I'm just holding it for the true owner. So the land transfer tax was actually paid by the true owner from the very beginning. So therefore, they can take advantage of what is known as a nil transfer. And this is for Ontario, just to be very clear.
Right. So let's say I just bought a house a couple years ago in my personal name, but I didn't have a bare trust. And now I want to transfer it into my corporation. I can't just do that without paying the land transfer. I'd have to pay it.
Correct.
Right. Okay. Only if the bare trust is in place. Got it.
Yes.
Can you think of any other ways that the bare trust would be beneficial, or did we kind of cover the basics?
We've covered the basics. I mean, there are lots of technical nuances, and I always say speak to your lawyer and your accountant to see, does this work for you? And even your mortgage broker should be involved because it can have implications on financing, both positive and negative. So make sure that, it's being considered and thought through.
Okay, cool. Now, let's dive into a bit of the structures for real estate investors. So I know we were touching on this a little bit, but earlier, the 3-tier corp structure.
So there was a trend, and I think this was going back to the RAIN days, and I'm not really sure. I still see a lot of people come to me and say, oh, I need to set up the 3-tier structure. And for me, until you reach a certain stage, the 3-tier structure is an exercise to make your lawyer and your accountant wealthy without adding any meaningful value to you.
Can you just give a brief explanation as to what that is?
So 3-tier structure at a high level, and again, there are variations to it, but there's the corporation that will own the asset or the land or the property. 2 is the property is the holdco that is going to own the shares of this operating company that owns the asset. And then the 3rd is to create an active property management company to turn passive income into active income. So that's essentially the 3-tiered structure that you will set up. The property management company will then have like a management agreement with the holding company to manage the asset.
Okay, so this is, you said people are coming to you and asking to get this all set up, but it's not always beneficial, like you were saying?
And I think it's very important for real estate investors to understand when they get advice or they sign up for coaching programs or whatever they're actually doing, is to understand that whoever they're working with, whoever they're getting advice from, actually takes the time to dig deep on their goals. Because a lot of people get into real estate investing without knowing why they're doing it. They just see the wealth that is, and 100%, there's a lot of wealth to be got from real estate investing. But you have to see, how am I actually getting to where I need to go? And so is your goal to get one property for each of your kid, for example? Is that all you want to do? Then chances you may not even need to incorporate at all. Or do you want to go and get a portfolio of 20, 30 doors? Is that the right structure for you? Then there's also the structure of, do I want to do some development, some flip? How do I want to do that, right? Do I want to have some long-term holds or some flips? Once you know what you accomplish, and again, you can vary and change, but once you have a set target, at least of what you want to accomplish, then you can get customized, tailored advice to you, right? Because, for example, if you want to have long-term holds and you have, say, you got teenage children where maybe, the properties will be passed down to them, then you have to think about the estate planning, because the corporation, while it may not necessarily give tax advantages, and there are some tax advantages to incorporate, but there are other reasons to incorporate when you're a real estate investor beyond just taxes. One of which is estate planning, because when you die in Ontario, If you just have a single will and you don't have a corporation or anything like that, and your property is owned personally, you will pay a state administration tax of 1.5% on the value of the real estate. Certain exceptions apply, but as a general rule, you can think that I'll pay 1.5% estate administration tax. Now, if you own that property in a corporation and you had a primary and a secondary will, or a personal and a corporate will, depending on what they're called, it's interchangeable terms, then you can actually result in having you can actually have a result where you don't have to pay the 1.5% estate administration tax, which is obviously a very attractive outcome.
So that 1.5%, the estate administration tax, that's completely avoidable if you have a corporate will?
If you have a corporate will, you don't pay the estate administration tax on the assets in the corporate will.
Okay, that's interesting, because let's say you own, I don't know, $1 million of real estate free and clear, then that would be $100,000. Is that right?
If it's $1 million, it'd be 10,000.
Sorry, 10,000. Yeah, $10,000 that the person would be
15,
saving.
Right? Because 1.5.
Oh, sorry, yeah, 15. Numbers are way off. $15,000 that the person would be saving, and this is a lot for somebody who may not have that money like just sitting there, right?
100%, because that tax has to be paid. I mean, you can delay it if you genuinely don't have it, but typically, when your executor applies to the court for a certificate of appointment of state trustee with a will, then you will have to pay that at that time. Like there's a bank draft payable to Minister of Finance when you do that.
Before they release the funds to you?
Before they even give you the right to manage the estate of the deceased.
Got it. And is this just for the value of the properties that are owned, or is this...
It's all your assets.
All the assets. So let's say you own, again, $1 million property, but there's a $900,000 mortgage.
Then it's $100,000. It's net.
Paying, so you're paying $100,000. You're paying 1.5% on $100,000.
Yeah, and then also the other thing that people need to understand is it's not just real estate. Like I know we're here talking about that a lot, but it's also other assets, like your personal belongings. Jewelry, furniture. People have different values and different things, right? That you can also put into your corporate will. That's why I prefer to call it primary will versus secondary will. Because or registered assets versus non-registered assets, because that gives a more accurate description of what you can accomplish by using the dual will mechanism to, save some money for your next generation, in truth.
Yeah. Now, what about if we combine the two things we're talking about? Let's say you have a joint venture and then you have a party that is no longer around, they pass away. How does that then work? Like things get a little bit complicated in that situation?
Well, a good JV agreement should 100% address what happens in the event of death, disability, because otherwise, essentially, how can you have... Without it, like you might end up being stuck with the estate of, or the spouse of your partner, or the kids of your partner or parent, whoever it might be, and now you're in a venture with them. Like, is that really what you want? If it's an active partner on title, if the mortgage starts getting called in and things, you need to know. You have to have a planned out strategy for what happens, right?
Sure. Yeah, I'm just thinking, like, let's say you agree in the joint venture agreement to sell the property immediately if somebody passes away. Are you able to do that, or is there a process that you'd have to go through before you can actually
sell? To get the certificate of appointment. If it's the party who was on title to convey real estate, you will have to get the certificate of appointment of a state trustee, unless certain exemptions, for example, like the first dealings exemption applies, which is not very rare, but quite rare.
Okay. So let's dive in a little bit more into this estate planning thing. So we talked a little bit about the wills. What else can you teach us about estate planning? What would be important to know for investors?
I think excuse me. I think a big part of what you need to figure out with estate planning is you need to think about, where do I want my assets to go and to whom? A will is just one document that says who gets what when. But there's also the planning part that talks about, how am I strategically preparing my assets to move them along? What assets do I want to pass on? What assets should I liquidate in my lifetime? Part of estate planning is also understanding, what will I need to retire on? How much income do I need to generate to have a good retirement? And then what if I have like a catastrophic major health issue where I need hospice care or, specialized nursing or something to that effect? How am I going to fund that? So once you've thought those things through and have a plan and understand your own risk tolerance, then you can actually get into what am I going to do to actually achieve this? That there are other tools, like for example, life insurance is a great tool that if it's something you're open to, that you can use to benefit both yourself and your next generation, because you can keep more money for yourself. Also, it's a dying, unfortunately, weirdly to say it this way, is a great time to make a charitable donation, because you get 100% deduction upon death when you're making a charitable bequest. And you're going to have to pay capital gains anyway on what you're going to, when you die. So might as well rechannel some of those dollars and at least put them towards a good cause instead of giving it to the government. I mean, I know there are a lot of your listeners who might feel the government might be quite wasteful with their tax dollars and would rather give it to good causes.
Right. So
it's about an awareness of what they can actually accomplish. Then the other things, like you can set up is, for example, understand your children and understand who your other beneficiaries are. And you can take advantage of structures such as family trusts. And, keeping in mind, again, there's a 21-year vehicle before disposition has to happen, or just at least the tax has to be paid, and then you can restart the clock on that. So that's another vehicle. If you have a blended family, you can think about spousal trusts and that, where you can make sure that your spouse gets provided for and can stay in the home that, you've owned forever, but to make sure that ultimately the property does come back to your kids. And spousal trusts are very, very delicate because you can taint them, where you can destroy the concept of it being a trust and defeat your intention of ensuring that your bloodline, like your kids, end up getting the property. And also, if you're blended families, there are things like agreements not to change wills, but drafting them effectively, noting how you're setting your executors up to make sure that, when I die, my surviving spouse doesn't just change the will to say everything to their children.
Yeah.
So it's all about actually taking the time to understand and have a discussion. And then some people, like we were talking earlier, like I was sharing my story that I come from Kenya and everything like that. I mean, you're sharing from Lebanon. Our families might have assets in a foreign jurisdiction. How does that tie in? Do we need a will in that jurisdiction? Sometimes we do not just a primary, secondary will. We then have a primary will for assets in Canada, secondary will for assets in Canada, and then we have a will for assets in the United States. Because in the United States, you can have things called living trusts and things like that. And again, depending on the state you're investing in and where you might have the assets, that again, you set up a structure that actually works with the laws of that state.
That's interesting, actually. Sorry to interrupt you there, but for someone who is investing in the U.S., so if they have a will here, does that not automatically cover their assets there?
It may. If you just have one will, it would.
Yeah.
But that might not be the most desirable outcome. So also it's to understand that what is actually the most desirable outcome, right? In terms, it's not just like, oh, well, this will covers it all. Sometimes it's like you don't want it to. So you have to make sure that you're setting it up in the right way. And even just, this goes into even buying real estate, right? Like, for example, in Arizona, there are certain types of deeds that you can create that can help you avoid paying the state land transfer tax. But again, a probate tax. And you need to understand that, how does this work? Am I setting it up in a way? And it's all about making sure you have the network of professionals that know what they're doing, or if they don't know, can connect you with people that do know.
Sure. On that note, just out of curiosity, I know it's always case by case whenever you're doing a will, but in general, do you have advice for people that have children, and should they, is there a certain age that would make sense for them in general to release funds to their children or to give them access to the ability to sell properties or to do that sort of thing? Do you have any just general advice on that?
So generally, I always like to create testamentary trusts if there are minors involved. Now, some people, if they want their kid to be an executor and the kid's still like in their early 20s, but they don't have anyone else, they trust their kid, then the testamentary trust is a bit of a redundant vehicle.
What is that exactly?
A testamentary trust is putting your assets, the capital assets specifically, into a trust that's created upon your death so that the kids do not have unrestricted access to those funds. So how does that look like? So for myself, what I've done is I've said that if I pass away, my children are minors, within 3 years of my death, or they turn 18, whichever comes first, the income of my assets can start being paid out to them, because the income at that point gets taxed at the highest marginal tax rate if it's kept in the trust. That's not advantageous to anybody.
Right.
So that gets paid out. But for the capital, I have put that they can get 25% at the age of 25. They get 50% at the age of 30, and they get the balance age of 35. Now, I know people will say, well, but what about university? What about this? What about that? Like, I need the capital for all those purposes. And I would say at that point that what you would do is you would actually tell them that, well, for the capital, I'm going to give my executor the power. I'm going to say that they can have the power to pay for education, for healthcare, for all those other factors that can be beneficial. List them out
specifically, right?
Yeah, there's a clause in there that I specifically say that for all these reasons, the executor can encroach on and override my wishes to make sure that they can accomplish these targets and these tasks.
What if somebody doesn't have a lot of cash in their portfolio, but they have a lot of real estate? Now, who's going to be responsible for taking care of that? Let's say you just have a couple properties, no joint venture partners, you pass away, you have kids, and they're 5 years old. What happens there?
So generally speaking, if you have a kid 5 years old, that's a long time to keep a trust open. Like, I mean, if you think the property is going to appreciate and there's value, then sure, you can keep the testamentary trust going. But what I would say is you keep the principal residence for what the kid needs to live at. And the rest, personally, I'm on a high level. This is general. I mean, obviously, it's fact specific. Yeah. But I would say that you'd want to probably liquidate other real estate at an opportune time when the market suggests you can make some good money on it, simply because you'll probably need the money for the kids' welfare and well-being. Because it's going to be, if that's all you have is 2 properties, chances are the rental income alone, because the parents probably were earning other income that's now no longer there, is not going to be sufficient to support the kids. Obviously, they need a roof over their head. Yeah. But having assets tied up to give the kids less quality of life doesn't make a whole lot of sense.
Sure. So typically there would be somebody in charge of selling that asset, like
the executor
that's appointed. Yeah, the executor will be responsible. Or sometimes it could be 2 executors, right?
Yeah, you can have as many. There's no limit on numbers. You just need to make sure that they work cohesively together, so that you're not just getting caught up in arguments without actually getting anything done for the benefit of the beneficiaries.
Right. Yeah, there's so much to think about, because like you can. There's tons of ways that you can go about saving money for your children, for the people that you're passing your assets on to.
And this is where I tell people that, you know, getting the right advice and finding who should I be getting the right advice from is so important, because there isn't a one size fits all. And it always scares me, especially people who've got like real estate and they say, yeah, I got my will from like willlawdepot.com or, you know, from like Staples. And I'm just like, do you really understand like what you might be costing yourself? You think you're saving yourself a few $100, maybe a few $1,000, but you're going to cost yourself a lot more invariably. If you got real estate assets and you got minor children, you should be speaking to a lawyer, a legal professional who you feel comfortable with and you trust about these matters.
Yeah. Is there anything else as part of the will that somebody should understand? Because, you know, depending on where you go, who you speak to, you may not get all sorts of information. And obviously, it's important to speak to the right person. But if you're just trying to gather general information, what else is important to understand about the will?
Understand the powers you're giving your trustees. Because, for example, if you don't have a close family friend or whatever, a close family member, and you need to ask a friend, allow for executor liability insurance. Make sure there's a clause in your will.
What is that exactly?
Executor liability insurance is insurance that essentially, if someone agrees to act as your executor, your estate will pay for insurance policy to be bought, so that if your beneficiaries sue them, as long as they didn't commit malfeasance, like they didn't do anything bad egregiously, then the insurance will protect them from any claims and will help them defend any claims brought by any beneficiaries. Because right now, it's scary, especially when you have complicated assets and you're dealing with real estate. Like, imagine just using a simple case example here is, say there's a piece of real estate that it was debatable whether it was a good time to sell it or not. The executor decided to sell it, and it ended up being the wrong decision. Now the beneficiary is suing the executor. That's a scary situation to be in, right?
Because but this would be generally in a case where the beneficiary is over 18, right?
Well, if the beneficiary is minor, then you can have potentially the government suing. The Office of the Children's Lawyer might sue, saying that you made an improvident sale to the detriment of the child. So you want this insurance policy in place to make those decisions, and also just gives them confidence to make good decisions, as long as they're making them in good faith and they're reasonable, that you know what, they'll be protected, because otherwise you might not have anyone to act as executor, or you might have someone who doesn't know your situation or family, and they might make even worse decisions, right?
But you don't need permission from someone to be the executor, right? Like when you're creating will, you can just decide who the executor is.
But they have to agree to be the executor.
They have to agree. Do they have to sign a document or something?
Well, but when you die, they have to actually file the application to be appointed to the court, because you're stating, in a will, you're stating your wish, you're stating your desire.
Yeah.
But ultimately, they have to step up and say, yeah, I'm going to do this, and go to a lawyer or do it themselves and fill out the application to do the estate administration when you pass on. So you definitely want someone who's agreed to do it and knows what they're getting into. And related to that is executors are entitled to compensation. Now, compensation is obviously, like any work, is taxable. So you have to also talk to your executor and say, do you want to have taxable compensation? First, do you want to get paid for doing this? Because sometimes if it's your sibling or others, they might say, no, it's his family, it's the right thing to do.
Yeah.
Now, if they want to get paid, then you have to think about, do they want to be paid in a taxable way that can delay your estate? Or do you want to give a gift? But then sometimes with the gift, they can take the gift and not fulfill their responsibilities. It's also, you have to know whether you trust the integrity of the person you're giving it to.
Sure. Now, what happens if the executor passes away as well?
So you can often name alternate executors. If this person's unwilling, unable, and my estate is not done, then I appoint so on. I usually encourage clients to name at least 2 alternates. Then they're first, so that usually covers it off. And if there's any change, I say you should update your will if something happens to one of the 3 people you've named prior. The other thing is if you're already acting as an executor of someone's estate, then I always say that you should amend your own will. Especially if you know their will you were the last in the line, so to speak, then your will should say that I was acting as executor of this person's estate, and I appoint this person now to take over that responsibility for me.
So just to kind of give an example, let's say you have a husband and a wife and a child. So the executors in this situation would be either the husband or the wife first, assuming one of them passes away. And then after that would be, like, say, for example, a sibling or 2 siblings. So now you would have technically 3 executors in this case?
No, because first it would be the person you appointed, right? Like like your wife or your husband.
Yeah.
Then if they're not available, then you come down to the 2 siblings, and then they would work together.
Sure.
And then if one sibling died, then it would be the one surviving sibling.
Yeah.
So that's how it would work.
So in total, you technically have 3 executors.
Potentially.
Yeah. Sure. Okay. So that would be generally sufficient, you would say?
Yeah, because at that point, if something happens to one of them, then you can obviously change your mind and, redo your will at that point.
Yeah, and then replace, potentially, as cold as that sounds, but replace the executor that passed away.
Exactly.
Yeah. Okay. So that's good. The executor liability insurance, that seems a little bit odd to me. Like, why would you want to protect the executor? But I guess from your perspective, it's like to give them the confidence to make the right decisions, right? Because if they don't have insurance, then they might be afraid to make certain decisions.
Correct. And you're not protecting them from egregious decisions, right? So if they were grossly negligent or like they were stealing or doing something fraudulent, the insurance doesn't protect that. It just protects from genuine good faith decisions where someone might frivolously sue them, to give them confidence that they're not going to end up being tied up in litigation because they were trying to do a nice thing.
Sure. Okay. Anything else in general on the will that somebody should understand?
I think we've thrown a fair bit at your clients. I think they might just be like, George, what are you doing to us right now?
Yeah. Maybe one last thing. What about the difference here between if you're doing a long-term hold or if you're flipping?
If you have a long-term hold, you want to have, ideally, at least have it beneficially owned in the corporation so you don't pay the estate administration tax.
Yeah. Okay. What about flipping?
If you're flipping, I mean, obviously the new rules that have come in this year about flipping and how that's taxed. But generally speaking, then it doesn't really matter because it's not an estate planning consideration because, I mean, unless God forbid something happened to you when you were in that position where, you were mid-flip and, you passed on, generally it's not really an estate planning consideration.
Sure. Okay. Aside from these topics here that we've covered, do you feel like there's anything else on your end that you'd want to discuss?
Honestly, it's just that make sure you get informed and that talking to people who can advise you on the changes in law. Like even, for example, like with title insurance, right? Talk to a lawyer who can actually explain to you in detail the value of title insurance. We've all seen the news where people are getting properties sold under them without knowing what's happening. If you have a good title insurance policy, it will help you prospectively with those matters. And a few years ago, it used to happen not with people actually selling the home, but people just putting mortgages on homes that were free and clear. So again, that's something that you need to be careful of, because
how do people do that? Like they
fraud.
fake the ID?
They fake the IDs.
Right. So they're going to like maybe like a fraudulent mortgage broker potentially that may understand what's happening also, right? And
they're sophisticated. Like this is coming. This is not like your mom and pop fraudster, right? Like this is like organized crime. We're actually taking the time to, create like very authentic looking IDs. Like we've had a couple of clients come in claiming to be so and so, but what we do is we do a lot of our title insurance through Chicago Title, and they have an enhanced verification check, and we put it through there. And we've had like clients fail it, and if we don't know you, and you're buying a property with us or refinance a property with us, you're going to go through the enhanced verification check.
Yeah. So I've never actually done a title insurance claim for any reason. Can you maybe just give a few examples of when it might be used?
So, for example, one of the most common that we see is because when you buy residential property, one of the things about getting title insurance is you don't have to get like a water certificate to prove that water bill has been paid. Now, unpaid water is attached to your property tax, right? If it's not paid in time. So now, if you go back to the seller's long gone, or it was a tenant.
I've actually had that happen with
or a tenant was supposed to have paid the water bill. The seller's like, this wasn't my responsibility, but ultimately it's on the tax bill of the property you own.
Yeah,
that's where your title insurance policy covers you off on that.
That was interesting. That was the exact situation that happened to me, and this was for a 5-plex.
Yeah.
So the water bill was like pretty high. I think it was $850 or something. But for some reason, the lawyer I had worked with said that he can't do anything about it. I don't know why.
Did he actually tell you? Did you purchase title insurance?
Yeah, I think you have to, right? You have to get title insurance.
I mean, generally, if you're getting mortgage financing, the banks will require it unless you have an up-to-date survey.
Yeah.
So I'm surprised that your lawyer didn't advise you that you could use title insurance to essentially deal with this claim.
Right.
Because they will deal with it. Most often, what title insurance simply does is they will pay the bill just to get it done.
Yeah.
And then they'll send it to a collections agency against the previous owner.
Oh, yeah. See, that never happened. I just paid it out of pocket, but good to know.
Yeah.
Now, what about an example where you buy a house thinking it's a duplex? They have it listed as a duplex in the listing, and you're under the impression it is, and then you find out later that it's a single family home. Is that title insurance?
Title insurance will, as long as you genuinely did not know.
Yeah.
Now, willful blindness, like where you just choose to ignore what should have been blatantly obvious, doesn't suffice, right? But
sure.
Otherwise,
so what would happen in that case? How would title insurance compensate you for that? Would they pay to legally convert it to a duplex in that situation, or
it depends on what your adjuster wants to do and also what your intention is. That can become the negotiation with title insurance. Obviously, they will look to push for the cheapest outcome, but like with any insurance.
Sure.
But it's something that can be negotiated. I have seen them support applications to change a single family into a legal duplex, because it was like legal non-conforming in this case. Was what it would been. They've been told it was legal conforming, but the reality was legal non-conforming.
Yeah.
So they just got it legalized.
Okay. Maybe one or two other examples of title insurance.
So prospectively, it protects against mortgage fraud. We talked about that. Property boundaries. If your property is encroaching on your neighbor's property, or your neighbor's property is encroaching on yours, to help resolve those disputes, fence line, boundary line disputes, title insurance is extremely useful for that. And then if there was, for some reason, your lawyer made an error with the Planning Act, and the seller owned abutting land, which the Planning Act prohibits, or had subdivided it without getting the proper permits or approvals, then title insurance would also help address those issues.
Okay. Sounds good. Well, thanks. I think we covered a lot here. Do you want to, is there any final words you want to share?
Honestly, the key is there's a lot of information out there. Make sure you seek it, because as many fortunes as there are to be made in real estate, if you're not getting the right advice, or specifically if you're getting the wrong advice, it can lead you to significant financial losses. And I'm sure you have seen that a lot from your clients as well. If they don't listen or get bad advice, they can end up in some tough situations. And that's what I love. I love helping people avoid the tough situations and have a great experience as they create wealth for their families.
Awesome. So do you just want to tell people how they can reach you? Your services are obvious, but just the best way to reach you.
The best way is you can get my email from my website, or you can contact our firm on Instagram at hsklawfirm.
Awesome. All right, Hussein, thank you so much for coming by. I know it was
my pleasure.
A long drive for you, taking the time out of your day. So appreciate it and looking forward to staying in touch.
Awesome. Likewise, George.
Thanks for listening to this episode. Your support is truly appreciated. And if you can share this with a friend or family member that might benefit from the information, remember, our goal is to motivate and inspire others to take action and to build wealth and to become well off. Enjoy the rest of your day.